Good morning and welcome to our webinar today. A new topic, surprises in the employment relationship, what you don't know can hurt you, presented by CEO and Chief Counsel Chuck Borek of the Borek Group, LLC. Elville and Associates is also very fortunate to have Chuck as special counsel to our firm, available to advise our clients on all business law and tax related matters. My name is Jeff Stauffer, Community Relations Director with Elville and Associates, and I'll be moderating today's webinar. So how this will work today, if you're new to our webinars, if you are, welcome, we're glad you're here, as well as to those who have been with us before. You as the attendee are currently in listen-only mode. However, if you have questions, and we really want to encourage you to ask questions throughout, please note them in the questions panel on the right-hand portion of your screen, and I'll forward them to Chuck during the presentation. We'll pause periodically throughout to address your questions, and you receive the presentation by email ahead of time for your convenience to take notes on it if you wish as well. If you didn't receive the presentation, it is in the section marked handouts on your panel to download it at this time if you wish. For certified financial planners, CPAs, and other professionals on today's webinar, you may receive 1.5 continuing education hours for attending. If I do not have it already, for my records and per the requirements of the CFP Board of Standards, please email me your board ID. And for CFPs only, I also need the last 4 digits of your social security number at your earliest convenience. Everyone will also receive a post-webinar feedback email right after the presentation, and I ask that you please just take a couple minutes to complete this simple survey to offer us your thoughts about the presentation. It's also an ideal time to request a consultation with Chuck if you have any planning needs at this time. So right now I'm going to introduce Chuck to you. It's my pleasure to do so. Chuck has been a presenter for us on numerous topics over the past year and a half, and we're happy to have him back. So I'd like to offer a proper introduction to him. So Chuck Borek is a business and tax attorney with almost 30 years of experience representing individuals, small businesses, and nonprofits. Chuck earned his joint J.D. MBA summa cum laude from the University of Baltimore, where he was the editor-in-chief of the Law Review and the recipient of the 1993 Law Faculty Award. He is currently an adjunct professor of law at American University, was previously on the faculty of the University of Baltimore School of Law, and has lectured at Dickinson Law of Penn State University, the National Constitution Center, and the American Law Institute. Chuck has written for Thomson Reuters, Bloomberg BNA, and the AICPA, among others. His book on contract drafting, which is in its 3rd edition, is used by lawyers throughout Maryland and has been cited by the Maryland courts. Additionally, Chuck presents seminars to CPAs and lawyers around the country through his company, the Borek Group, LLC, including presentations to Big 4 accounting firms and Fortune 500 companies. He lives with his wife, the youngest of their 4 children, and 2 dogs in Howard County. Chuck also holds a graduate degree in theology and literature from Wesley Theological Seminary and is pursuing his doctoral work at Pittsburgh Theological Seminary. So welcome, Chuck. We appreciate you having you back and look forward to your presentation today. I'll turn it over to you.
Thank you very much, Jeff. I appreciate that. And welcome everybody to our webinar this morning. So we're going to focus on issues that employers have. And my presentation slide says the top 10 concerns for employers. So I'm going to, just as a way of organizing this discussion, focus around 10 concerns in particular that employers need to have. In my opinion, employment issues are the most dangerous issues in business. And I say that for 2 reasons. One is because, in my experience, very often they're misunderstood. A lot of the rules we're going to be talking about, are misapplied. We'll see that right away when we encounter our first concern today. The second thing is, the second reason that I think this is a dangerous area is that employers tend to think that they don't have any real concerns or issues with employees until they get big, right? A small business starting out generally their first hire isn't a personnel coordinator or a human resources person. People tend to look at that and think, well, that's for the large companies, right? When I have, 50, 100, 1,000 employees, that's when I need, to worry about employment concerns. But as it turns out, there are employment concern worries or employment law worries, as soon as you have your first employee. And in fact, if you're operating in the form of a corporation or LLC, it's conceivable that even with just the owners, you may have employment concern. We'll talk a little bit about that today. So there's all sorts of hidden issues that people think maybe don't apply to them, or they don't think they have to be aware of any issues if they only have a few employees. But many of the things we're going to talk about today applies no matter how many employees you have, whether it's 1,000 or 1. So for those reasons, it's a dangerous area, and that's why I want to talk about it. And I'm happy to have this opportunity to talk with you about it today. Now, the last thing I want to say before we begin is that each of the things we're going to talk about is a rich and deep subject in and of itself. I could, and in fact do, full day seminars and webinars on most of these topics. So most of what we're going to talk about very peripherally. I'm going to try to explain the concern to you and give you enough understanding so that you're an informed person in that regard, so that you can identify what the potential issues might be. But just be aware that there's a lot more behind everything that we're going to talk about today. We just don't have time in our hour and a half together or so to really discuss any of these things in depth. But I think we do have time to at least alert you to what the major concerns are. All right, so here are the top 10 concerns I want to talk about today. First is worker classification, an oldie but a goodie, right? That's been around for a long time and is very, very commonly misunderstood. Then we'll talk about employment eligibility verification, new hire reporting, two things that people oftentimes aren't aware of. We'll talk about the Fair Labor Standards Act requirements, and that includes things like the wage and hour law and overtime pay. We'll talk about trust fund penalties, a major tax issue for employers. We'll talk about vicarious liability, workers' comp and unemployment insurance. We'll talk a little bit about employee handbooks and contracts. We'll look at the issue of nexus, which deals with multi-state taxation. And that's an emerging issue. It's been emerging for a while now, but states have gotten very aggressive in seeking out-of-state businesses to file the appropriate and pay the appropriate taxes. And then finally, we'll finish up our session talking about a whole host of anti-discrimination laws that apply to employers under different circumstances, right? So as you can see, it's sort of a wide panoply of things that we're going to discuss, and let's go ahead and get started. So the first thing we're going to talk about is worker classification. And the issue here is whether a particular worker is properly classified as an employee or as an independent contractor. That's a really important issue. It has all sorts of ramifications. Not only are the employer and employee interested in that, but so is the IRS and so is the state. Generally speaking, employers would prefer, if all things being equal, employers would prefer to categorize their workers as independent contractors. Why? Well, it's much simpler for the employer. You don't have to do any income tax withholding. There's no FICA, which is the Social Security tax. There's no federal unemployment tax or state unemployment tax for that matter. You don't have to provide any benefits. Right? An independent contractor relationship is very simple. The worker does work for you, provides you with an invoice, or you have a pre-agreed amount, and you write a check for that amount, and you're done. That's it. Right? That's the simplicity of an independent contractor arrangement. As I said, the issue, the thing you have to be concerned about is that it's not just the employer and the employee that are concerned about whether somebody is classified as an independent contractor or an employee. But the government, both the federal and the state government, are concerned as well, especially the IRS. And the IRS has taken great interest in this issue over the last few years. Here's the thing that people most commonly misunderstand. You can't just agree that a worker is an independent contractor. Whether a worker is an independent contractor or an employee is determined based on the facts. All right, the facts either show that they're an independent contractor or they show that they're an employee. You don't have a choice in the matter. You do have a choice, of course, in how you construct the arrangement, right? So you may be able to manipulate the facts, but once the facts are established, you're either an independent contractor or you're an employee. There's no choice involved. And that's a mistake I find a lot of clients make. I have clients call me and say, I want to treat this worker as an independent contractor. Can you draft something up so that they agree to be an independent contractor? And the answer is, well, I guess I could draft something up, but it won't have any effect if the facts indicate that the person should be an employee. Now, a real challenge in this area is that there's no sort of black and white statute that says, well, here's the definition of an employee. The definition or the distinction between an employee and an independent contractor comes to us from common law. Common law is law made by the courts. It's law that comes to us from cases, from a variety of cases that when you put them all together, they tell you what factors you should look at in determining whether a worker is an independent contractor or an employee. Many years ago, back in the 1980s, the IRS studied case law, studied the common law in this area, and came up with 20 factors. The 20 factors that they felt were most commonly used by the courts in determining whether a worker is an independent contractor or an employee. These are those 20 factors. Now, we're not going to go through each one of them in detail. We simply don't have time to do that. But it's important to understand that each of these factors needs to be considered. All right. There's no one factor that's determinative. And the other thing that you need to understand about these 20 factors is that it's not a test. It's not a 20-point test. In other words, if you categorize each of these factors as pointing either to independent contractor or employee, it's not like you can just say, all right, well, whichever the majority is, if the majority point toward independent contractor, they're an independent contractor, or if the majority point toward employee, they're an employee. That's not how it works. Right? The courts and the IRS both have made abundantly clear that you have to weigh the factors so that conceivably you could have 19 of these factors pointing in one direction and just one factor pointing in the other direction, but that one factor could have so much weight under the circumstances that would drive the conclusion. So this is sort of a complex analysis. Certainly, there are situations where the determination is relatively straightforward, right? So I don't want to give you the impression that in every circumstance, it's a very complicated determination of whether somebody's an employee or independent contractor. On the margins, it's simple. But of course, as with most of life, much of where we live is in between the margins in that gray area. And that's where an analysis should be done to get this right. Now, as I said, I'm not going to go through all these 20 factors, but I want to point out a few of them. The one thing I want to point out is the commonality among all the factors, right? The common theme that runs through all 20 factors is control. That's really what it boils down to. The more control the employer exerts over the worker, the more likely that they are properly characterized as an employee. So, for example, if you just pick out some of these factors, who gives the worker instructions, right? Generally speaking, and again, all of these factors could work either way, but generally speaking, an employer gives an employee instructions. You don't give an independent contractor instructions, right? When you hire me as your attorney, or if you were to hire me as your CPA, right, I'd be working as an independent contractor, right? I'm not your employee. Well, you generally don't give me instructions, right? You don't go to your CPA and say, all right, I want you to do my tax return, and here's how I want you to do it, right? And you provide the information to the CPA or to the attorney or to the doctor or whoever the professional is who's working as an independent contractor, and they perform the services in the manner they think is most appropriate. Who trains the person? Do the services have to be rendered personally? Normally, when you hire an employee, right, the next day you expect that employee to be the one that shows up to work. However, if you think of a common independent contractor situation, you hire a company to paint your house, right? Somebody comes out and talks to you about painting the house, and so you hire them. Well, you don't necessarily expect that particular person to come out and paint your house. That might be the salesperson for the company, right? The independent contractor, with an independent contractor, you're simply agreeing to a result, to get a result done. Who actually performs the services, generally irrelevant. Where's the work done? Does it have to be done on your premises? That's more likely to be an employee. Do they have to do reports? How do you pay them? Do you pay them for the job, or do you pay them by the hour? Number 14 should say tools and materials, not tolls and materials. Who provides the tools and materials? Is the worker in a situation where they could either make money or lose money? Well, that would indicate, or that's a factor at least that indicates independent contractor, right? Because employees generally don't lose money, right? Employee does work and you pay them. An independent contractor, however, typically has expenses, and in fact, it's possible that their expenses could exceed what you're paying them and they could lose money, right? Do they have the right to quit? Do you have the right to fire them? With an independent contractor, generally you have a contract, right? That's what contractor means in that term, which means that you can't just, dismiss them whenever you want. You can't hire somebody to paint your house and then when they're halfway done painting, say, "Oh, I've changed my mind. Go away. I don't want you to paint my house anymore." You have a contract with them to paint your house. Likewise, they can't go halfway through painting your house and then say, "Oh, we've got another job, so we're not going to finish this." I guess in either case you could do that, but in both cases it would be a breach of contract. There would be a legal remedy. Whereas with an employee can quit at any time, and the employer can fire them at any time. Right? Employees are generally employees at will. The IRS has sort of consolidated those factors into these three categories, by the way. And I only mention this so that, if you see any information from the IRS about the independent contractor issue, oftentimes you'll see these three categories and you might wonder, gee, where are the 20 factors? Well, the 20 factors haven't gone anywhere. They've just sort of, as I said, consolidated them into these categories of behavioral control, financial control, and the relationship of the parties. They haven't really changed the analysis. Now, if you have incorrectly categorized workers as independent contractors, this is something that comes up with some frequency in my practice. The good news is there is something called Section 530 relief. And if Section 530 relief applies, then that's a panacea. That's a get out of jail free card. Because if Section 530 relief applies, that means that all you have to do is correctly classify the workers going forward, and there's no penalty for what you've done in the past. Now, in order for this relief to apply, however, you have to meet these three requirements. Reporting consistency means that you've actually reported the payments to the workers the way you're supposed to if they were independent contractors, right? Which generally means you've sent them 1099s. So you have to have done that. You have to have substantive consistency, which means that all of the people that do work for you of the same kind have to be treated the same way. If you have 10 workers who are all doing the same job function for you, but some of them you treat as independent contractors and some of them you treat as employees, then you won't meet the substantive consistency requirement. And then finally, and this is probably the key one in most cases, you have to have some reasonable basis, right? And the law goes to great lengths to describe what reasonable basis means here. But there has to be some judicial precedent or some regulation or law or even industry practice that gives you a reasonable basis for treating those workers as independent contractors. Even though you may be wrong, there has to be something that a reasonable person would have looked at and said, well, that seems to mean that these workers are independent contractors. If you meet those three requirements, then as I said, it's a get out of jail free card. Even if the IRS says you're wrong and those workers are employees, not independent contractors, you simply have to correct that situation and you don't have any penalties or back taxes to pay. Now, if you are audited by the IRS and you've incorrectly classified workers, you could have a whole lot to pay. Because remember, if you're paying somebody as an independent contractor, the employer is not paying their share of the FICA taxes. Right? The employer is normally pays half of the FICA taxes for employees. Well, you haven't been paying that if you've been treating them as independent contractors. You haven't been doing withholding. So there's, and of course, there's all sorts of penalties that will apply. So if 530 relief doesn't apply, you may find yourself having to reach into your bank account to pay some penalties and some additional taxes. There is a process the IRS has using this form SS8. Either the employer or the worker can file a form SS8. This is basically a request that the IRS determine whether that worker should be classified as an employee or an independent contractor. Now, the most common situation where this is used as a practical matter is when an employer is treating someone as an independent contractor, and then the relationship sours, right? And the worker is looking for ways to get back at the employer, and somebody says to them, or they realize themselves that, well, they probably shouldn't have been treating me as an independent contractor to begin with, and so I'm going to get them in trouble by filing this form SS8. Right? And what the form is, of course, you only see a small portion of it here. The form asks for all sorts of information so that the IRS can make a factual determination based on your facts. What the procedure is, whichever party files the form SS8, the IRS then contacts the other party, right, the employer or the worker, as the case may be, and asks them for the same information. So the IRS gets both sides of the story, and then once the IRS gets that, they make a determination, and then that determination is binding on the IRS. Again, there's a variety of circumstances where you may want to use that form SS8. There is no user fee for using the form, but typically its use arises when there's some dispute as to whether the worker should be classified as an employee or independent contractor. I also want to mention very briefly this issue of statutory employee. This is a special status under the law. What's special about statutory employees is that they're treated as employees in the sense that you give them a W-2, but you don't have to pay some of the same taxes. And in fact, they get to use what's called a Schedule C, if you're familiar with that, which is what sole proprietors use on their tax return, so that they can deduct all of their expenses. So they're sort of a hybrid between an employee and an independent contractor. The key for the employer is that you have to give them a W-2. There's only 4 categories of statutory employees. You see them on the screen: agent drivers or commission drivers. These are folks that drive around in vehicles and sell your goods or services from the vehicle. Only certain types of goods or services apply here, basically food and beverage products or dry cleaning. Full-time life insurance salespersons. Again, they have to be full-time life insurance salespersons in order to be statutory employees. Home workers. Home workers are, in this sense, are people who typically assemble things in the home, right? It used to be a very big industry in this country, not so much anymore. But a home worker is someone who will get raw materials from the employer and they put the stuff together. It might be sewing, it might be some sort of craft, or some sort of a small goods assembly, and then they get paid by the piece, right? That's a home worker. And then certain traveling or city salespersons, again, not something we see so much in our economy anymore. All right, that brings us to our second concern: employment eligibility verification. It is illegal to employ a person in this country unless that person has authorization to work. And the employer has the burden of making sure that the person has authorization to work. This is something a lot of employers don't realize. They think they can, just sort of take somebody's word for it. They just assume if somebody applies to work, they assume that they're a citizen or otherwise eligible to work in the United States. But the fact of the matter is, an employer has a burden, and there are certain steps that employers must take under the law, and there are penalties for not doing so. First of all, there's a Form I-9. An employer has to fill out a Form I-9 for everybody they employ. all employees are required to have a Form I-9 filled out. Now, the Form I-9 is nothing you file. This isn't something you file with the government, and the government, keeps track of this or anything like that. But you have to complete one and keep it on file. What the Form I-9 does is it ensures that the employer has checked certain documents that demonstrate that the worker is eligible to work in the United States. And there's a list of documents that the worker can give you, but you have to do this. And this is for all employers. This isn't just for big employers, or if you have one employee, you have to fill out this Form I-9. Again, you don't file it anywhere, but you have to keep it. If the Department of Labor knocks on your door and they ask for your Form I-9s and you don't have it, you have big problems. Right? So you have to have a Form I-9 for every employee. This is the list of documents. The way the Form I-9 works is you have to have either something, one document from List A, or something from both List B and List C. All right, so you can see things on List A are things like passports and under employment authorization documents. List B and List C would be things like the driver's license and Social Security Social Security card. The difference is List A basically has things that will have both their identifying information and their photograph, whereas List B tends to have photographs, and List C tends to have information that shows that you're authorized to work in the United States. For example, if you have a driver's license, it doesn't necessarily mean you're authorized to work in the United States. You could be an illegal alien or a non-resident alien and have a driver's license. So that's why you have to have something from List B as well as from List C, or something from List A. Now, a couple of things about these documents. The law requires that the employer examine the documents, the original documents, not copies of them. And you don't need to keep a copy of those documents. Oftentimes, employers will copy whatever documents the employee gives them. And there's nothing wrong with doing that, I suppose. You can do it, but it doesn't really do you a lot of good, because since the law requires that you look at the original, right? If DOL comes to your place of business and audits you for this, showing them a copy of a document doesn't prove anything other than you saw a copy of the document. It doesn't prove that you saw the original. And there is no requirement that you keep a copy of it. So having a copy doesn't give you a leg up or anything like that. What you have to do on this Form I-9 is you have to certify that you in fact saw the original of the documents. You also cannot restrict the employee in terms of which documents they can use, right? They get to use any of the documents that are on this list. You can't say, for example, you have to show me a passport. That's the only thing I'm going to accept. You're not allowed to do that. All right. There's also something called E-Verify, which is, as the name implies, an electronic verification service. The way it works is you complete a Form I-9, and then you go to a website and you use E-Verify, and E-Verify will give you results typically virtually immediately. Some states require that you use E-Verify. Maryland is not one of them. However, oftentimes if you're doing government contract work, the government contract might require that you use E-Verify for your workers. E-Verify, as I said, electronically verifies the employment eligibility of employees, whether they're newly hired or existing. It's free. You don't have to pay anything for it. It is fast and pretty simple to use. It's something that the Department of Homeland Security and the Social Security Administration sort of jointly administer. So you just Google E-Verify, you'll find all the information you need on that. Again, not required in Maryland. Some states do require it. Maryland does not. There are about, last time I checked, I think 10 or 15 states that do require E-Verify, I'm sorry, for all employees, but Maryland has no such requirement at this point. So what if you hire an illegal worker? You have a fine, potential fine up to $3,000 per illegal worker hired, and maybe even more importantly, you could get up to 6 months in jail. This is a criminal offense. You could literally go to jail for hiring illegal workers. Now, they're probably not going to send you to jail just because you didn't do the I-9, right? But if they find that in fact some of your workers are not authorized to work in the United States, that's certainly a potential consequence. So this is an important thing. Now, one thing you should know is that the I-9 is required for all employees. It's not required for independent contractors, right? So again, that determination of whether somebody's an independent contractor or an employee becomes really crucial here. Having said that, I also want to emphasize, however, that it is still illegal to hire an independent contractor who's not authorized to work in the United States. All right, so you're still violating the law if you hire somebody who's not authorized to work in the United States as an independent contractor. It's just that you don't have to have a Form I-9 for them, right? That's the only difference. With an employee, you have to have a Form I-9. Right. Our third issue, new hire reporting. Again, this is one that I find my clients frequently are unaware of. They don't realize that under federal and state law, when you hire an employee, you have to report that new hire. People just are, I find oftentimes just aren't aware of this. They don't realize that when I hire somebody, there's a specific thing I have to do to report that I've hired that person. The requirement is that you report information on newly hired workers, whether they reside or work in the state. So even if they live out of state, if they live in Delaware, New Jersey, or someplace, or Virginia, and they're working for you, if they're working in Maryland, Maryland law requires that you report the new hire. In fact, even if they're living out of the state and working out of the state for that matter, it's probably not going to get you out of this requirement, because every state has new hire reporting requirement. It's a federal mandate, and every state has complementary laws. Now, the way you do it might vary a little from state to state, right? But this is required regardless of the ages of the employees you have. So, if you hire a teenager or something, you might think, well, maybe that doesn't apply to them. It doesn't matter what their age is. Doesn't matter if they only work a part of a day, or if they're still on probationary status. So you might not even, you haven't even decided if you're going to hire them full-time, or maybe they're just part-time, or maybe they're seasonal. And so you think, well, I don't have. You have to do the new hire reporting for every employee you hire. Again, this doesn't apply to independent contractors, right? So that distinction between employee and independent contractors becomes really important here. If they're an employee, you must do the new hire reporting. In fact, you have to do the new hire reporting even if you employ them only one day before they're terminated. You hire them today, you fire them tomorrow, you still have to do the new hire reporting. New hire reporting has actually been around for a long time. It's not brand new. When I talk to my clients about this, often they think this is some new requirement because they've never heard of it. It's actually been around since the 1990s. The primary impetus for new hire reporting it relates to child support obligations. Frequently, people who owe child support, the only way they don't pay it voluntarily sometimes, and so the only way the other parent gets it is through garnishment of their wages. Well, in the past, the way people would get around that is they would simply change employers. Right? They move to a new job, and therefore, you'd be hard to find them. And if you did find them, then you'd have to start the garnishing process all over again, and then we just keep changing jobs. Well, now with new hire reporting, there's a database so that whenever an employer hires an employee, their name goes into this database, and if they owe child support, the state knows exactly where to find them. In Maryland, you can do new hire reporting electronically. This is what the website looks like. Again, you can just, I've given you the web address across the top of the screen, but you can just Google Maryland new hire reporting and you'll find this. In order to do it online, you have to register. So typically, if you're going to, if you're hiring lots of employees or you frequently have employees, then registering to report the new hire online, is probably a convenient thing to do. There is a physical form you can use as well. This is what it looks like. And you can see up in the top left-hand corner of the form, it indicates where you send it to. You can either send it by mail or you can fax it. And again, it's the same thing. It's just on paper as opposed to electronically. If you're only hiring one employee, you don't expect to be hiring many employees in the future. And for some reason you don't want to register on the Maryland website, then you always have the option of doing it on paper. The penalty if you don't do this is $20 per month per employee. $20 per month per employee. And if you're doing this under an agreement with the employee, right? So in other words, the employee comes in and says, hey, look, I owe a bunch of child support. I don't want to have to, I don't want my wages to be garnished. So can we agree that you're not gonna report me as a new hire, or we'll pretend I'm an independent contractor or something. If the state finds out you've done that, then it's $500 per employee per month for not reporting the new hire. So again, this could potentially even apply if you incorrectly treat somebody as an independent contractor. Now, I've not seen the application of this in that circumstance, so I don't want to give you the impression that this happens all the time, but it's certainly possible that the state could come in, find out that you have a bunch of workers that are not, that you're classifying as independent contractors, even though they should be employees under the circumstances. It's conceivable they could say, look, not only have you not been paying your unemployment tax and your FICA tax and doing your withholding, you also need now to pay this penalty because you didn't do any new hire reporting either. All right. So that's a potential, a real potential problem. Somebody has asked a question. New hire reporting is required now in Maryland. When was this implemented? In the 1990s. It's been a requirement for almost 30 years. All right. So this is a classic example of a situation that employers aren't even aware of. I mean, I'll bet there are thousands of employers in Maryland, tens of thousands of employers who've never reported a new hire because they're not aware of it. Again, it's not a big issue. I'm not aware of the state going out and doing large-scale new hire reporting audits, but it is a requirement. And as I said, the requirement's broad. Doesn't matter what age the employee is, doesn't matter how long they work for you, even if they're on probationary period, new hire reporting is required. And these are the penalties for not adhering to it. All right, let's talk about FLSA requirements. By the way, this is also one of the reasons, as I said earlier, that I find this to be the most dangerous area, perhaps, of the law involving employers, because typically, especially if you're just starting out in business, right? Not only do you not think of these things, typically you don't even think to ask your lawyer about these things, right? Or your CPA or your advisor, whoever they are, because you figure, well, again, human resources, employment matters, that's stuff that's sort of more sophisticated. When I get bigger, I need to worry about that stuff. If I'm just hiring one or two employees or just hiring somebody occasionally, I don't have any issues. And so you don't even bring it up. You don't even ask anybody. Well, the fact of the matter is, as we've already seen, you may have issues and potentially serious issues. All right, so on that happy note, let's move on to the Fair Labor Standards Act. Actually, there's a typo. It should be FLSA, not FSLA. Fair Labor Standards Act. This is the minimum wage in Maryland. As of January 1st of this year, if you have 15 or more employees, it's $11.75. If you have 14 or fewer, it's $11.60. Those amounts change on January 1st of 2022 and 2023 and 2024 until 2025. Well, actually until 2026, July 1st of 2026, when it becomes $15 for everybody. So the $15 minimum wage in Maryland is being phased in, right? Currently, it's $11.75 if you have 15 or more employees. If you have 14 or fewer, it's $11.60. Now, that's the Maryland state minimum wage. Turns out here in Maryland, we have one jurisdiction that has its own separate minimum wage, and that's Montgomery County. Montgomery County, beginning July 1st of this year, if you have 51 or more employees, you have to pay them $15 an hour. If you have 11 to 50 employees, the minimum wage is $14 an hour. And if you have 10 or fewer employees, the minimum wage is $13.50. So note that in Montgomery County, the minimum wage is higher than it is in the rest of the state. You'll note that it goes up on July 1st, 2022. Well, it may or may not go up. It stays at $15 for 51 or more employees, but that is to be adjusted for inflation. So depending on what the consumer price index is, it may actually go up. It'll be $14.50 for if you have 11 to 50 employees, $14 if you have 10 or fewer employees. So again, there's a federal minimum wage, but the states can have their own minimum wage. Now, the state minimum wage cannot be lower than federal minimum wage, but it can be higher, as it is here in Maryland. Now, there are some exemptions, and I will look at these exemptions from two perspectives. There are exemptions from minimum wage and from overtime. Now, when you pay overtime, you have to pay at the rate of time and a half, whatever the hourly wage is, you pay at time and a half. We're going to talk in just a few minutes about whether or not you're even allowed to pay somebody hourly. Right, we'll get back to that. But there are certain categories of employees that are exempt from minimum wage and from the overtime rules. Amusement park or swimming pool employees, certain agricultural workers, camp counselors, commissioned employees, drive-in theater employees. Not that many drive-in theaters around, I suppose, anymore, but if you're an employee of a drive-in theater, there are exemptions from both minimum wage and overtime. Family members, you don't have to pay your family members minimum wage. You can cheat your family members, right? And that's what makes America great, right? You can mistreat your family members, don't have to pay them minimum wage or overtime. Only for immediate family members, by the way. Your second cousin doesn't count. Food packing employees, minors under the age of 16. Now, by the way, for all of these different categories, it doesn't necessarily mean there is no minimum wage, right? It's just that the minimum wage is modified for certain of these categories, and it's modified under different circumstances in for different periods of time. So again, I just want to give you an idea of the categories where the minimum wage and overtime is modified. Outside salespeople, so salesmen, I should say salespeople, right? Can be either man or woman. There's a category that refers to small restaurant, tavern, or cafe employees. That's basically a food establishment that has less than $400,000 a year in gross sales. Special education program trainees at public schools are exempt from both minimum wage and overtime. Volunteers, of course, right? If somebody's volunteering, then by definition, you're not paying them anything. And also white collar employees. Now, we're going to come back and talk about what white collar employees are in just a few minutes. Actually, maybe we'll do it right now. The Fair Labor Standards Act, again, that should be FLSA, not FSLA, says that you can pay white collar employees a salary. All right. However, and this is a federal law, if the employee is not classified as a white collar employee, then you have to pay them hourly. This has become a big issue. Many employers have traditionally paid their employees a salary because it's just simpler, right? Rather than having to pay them hourly and then having to pay time and a half if they work more than 40 hours a week, just pay them a flat salary. And they don't have to worry about calculating their pay every week. Again, just like with the independent contractor and employee designation, you're not allowed to just decide that, right? The federal law says you cannot pay a worker hourly unless they are a white collar employee, and there's 3 different tests to determine if they're a white collar employee. The first is a salary basis test. If you're going to pay them a salary, it has to be a fixed salary. I had a client just recently that said, I have this worker and I'm going to pay them, but I'm going to pay them a salary. And they said, well, their salary is a certain amount per day. And I said, well, what if they don't work a full day? And I said, well, then I'll pay them less. I won't pay them, the full salary. Well, then it's not a salary because it's not a fixed amount. It varies based on how much time they work. Right? That's not a salary. If you want to pay somebody a salary, it's got to be a salary, a fixed amount of pay they get every week, or I guess conceivably you could do it every day. but it has to be a fixed amount that does not change with the amount of time they work. There's a salary level test. They have to be making at least $684 a week. That equates to $35,568 a year. If you're not paying them at least that amount, you cannot give them a salary. You must pay them hourly. And then finally, if you meet the first two tests, there's a duties test. Only employees that are involved in executive, administrative, or professional work are allowed to get a salary. Now, there are specific definitions of those things. For executive, their primary duties have to be management. It doesn't have to be management of the whole enterprise. It can be just a department or a unit of some sort. They have to customarily and regularly direct the work of 2 or more employees, and they have to have the authority to hire and fire other employees. They don't meet those requirements, they're not an executive. Well, what about administrative? Well, administrative is probably a little different from what you might think it is. In order to classify someone as administrative for this purpose, their primary duty has to be to do office work, but most importantly, their primary duties have to include the exercise of discretion. If they are not using their discretion and independent judgment with some matter of significance, then they don't count as a white-collar administrative employee for this purpose. And unless they meet some other requirement, you would have to pay them hourly. And then finally, you have professionals. This is one category that probably means pretty much what you would expect it to mean, right? Somebody who's performing services in a field where advanced knowledge is required. Certainly, if a license is required to do whatever it is they're doing, then there's a good chance you qualify as a professional. Also, artistic workers, actors and dancers and stuff, they count as professionals for this purpose. So again, remember, you have to pay an employee hourly unless they fall into one of the 3 categories we just looked at, right? Executive, administrative, or professional. You're paying them at least $684 a week, and you're actually paying them a fixed amount. Otherwise, if you don't meet all 3 of those requirements, then you must pay them hourly, which means unless there's an exemption like the ones we just looked at for overtime, you have to pay them time and a half for overtime work. There have been many, many lawsuits in the last few years when people have worked, in some cases for years, right, and been paid a salary. If they can go back and prove how many hours they worked and how much overtime they should have been paid, employers can be liable for those amounts and even additional amounts, including in some cases punitive damages. Now in Maryland, there are additional exemptions from the minimum wage only requirement. So in other words, you still have to pay these people overtime, but you don't have to pay them minimum wage. Certain disabled workers, now I don't want to suggest that all disabled workers are exempt from the minimum wage, but there are certain circumstances when a disabled worker is working under a Department of Labor or Department of Licensing and Regulation certificate that they might be exempt from overtime. Tipped employees, right? You generally don't have to pay tipped employees a minimum wage. In Maryland, the amount you do have to pay them is at least $3.63 an hour. So you do have to pay them at least that hourly amount, but you don't have to pay them up. You don't have to pay them the actual normal minimum wage. And then also there are exemptions for people who are under 20. Remember, earlier we looked at an exemption from both minimum wage and overtime. If you're under 16, there's an exemption from the minimum wage only if you're under 20. Now that only lasts for 6 months, by the way. If you're under 20, after 6 months, you got to start paying them the regular minimum wage. And then finally, there are exemptions just from overtime, right? So these are people who you have to pay minimum wage to, but you don't have to pay them overtime. Assisted living facility employees, automobile dealership employees, bowling alley employees, motor carrier employees, railroad employees, theater and music venture employees, if it's for a nonprofit, and finally, taxi drivers. Okay, so those are all the folks. Those are all the exemptions under Maryland law from the minimum wage or the overtime requirements. Again, this is a little bit more complex than I think a lot of people appreciate. They figure that whether I pay somebody a salary or whether I pay them hourly or whether I pay for overtime even, is just, whatever I decide to do or whatever we agree upon. And nothing could be further from the truth. It's another common misconception, comp time. People say, well, I don't want to pay overtime, so I'll just give my employees comp time. If they work more than 40 hours in a week, I'll let them take some time off in the future. That's a violation of federal law. You can't do it. Now, you can do it within the same week, right? So if somebody works 10 hours today, you can say, all right, well, tomorrow, you only have to work 6 hours because you worked an extra 2 hours today. Within the same week, you can do that. But if somebody works more than 40 hours in any given week, unless they're properly classified as a salaried employee, you must pay them overtime. You cannot use comp time in lieu of overtime. That's a violation of federal law. All right, let's move on to the fifth of our 10 concerns, the trust fund penalties. This is a very dangerous thing. Lots of employers get in deep trouble, deep tax trouble with respect to trust fund penalties. So let me explain to you what we mean by the trust fund. And the trust fund penalty, by the way, used to be called, and still is sometimes referred to as the 100% penalty. And I'll explain to you why that is. When you have payroll, right, you have an employee, you determine their gross wages, right, and that's based either hourly or potentially on salary, right, if they qualify for salary. And then a couple of things have to come out of those gross wages. The employee's share of FICA, right, FICA is a Social Security and Medicare tax, as well as income tax withholding. Right, you're required to withhold income tax from the employee's pay. So both of these things in the blue box that you see on the screen, the blue boxes, those are both the employee's obligation. However, the employer has the obligation to withhold it from the employee and deposit with the government. Right, so when you take gross wages and you subtract out your employee's share of FICA and the income tax withholding, that gives you the net pay. Note that there is also an employer's share of FICA. That's separate and apart. That's the employer's own liability, independent of the employee's liability. Now, these two things that we see in the blue boxes here, those are what are referred to as the trust fund taxes. They're referred to as trust fund taxes because, in essence, the employer is required to keep them essentially in a trust fund. You hold on to them until you're required to deposit them. And whether you have to deposit them monthly or weekly or daily depends on how large your payroll is. But during the time you have them, they're held in trust. It's not the employer's money, right? That's the key thing here. It's money that belongs to the employee. It's just money that you have, rather than paying them, you have held it back in a trust fund because the government requires that you do that. The way a lot of employers, of course, get themselves in trouble is oftentimes it's at least its origins are innocent, right? The employer thinks, well, I have some cash crunch, right? I got to pay my rent or I have to pay other employees. I don't have any cash. And so what I'll do is I'll take that trust fund money. It's just sitting there. I don't have to deposit it maybe till next week or whatever. And so I'll take that money and I'll use that to pay these other things with. And then I'll put it back. By the time I have to deposit it, I'll make up for it. And of course, we know what happens to best laid plans. Sometimes it doesn't work out. You don't have the money to deposit. It doesn't get deposited. Here's the key with the trust fund penalty. It becomes a personal liability, not a company liability, a personal liability on anyone who had the ability to pay it. So even if you're not the one that's primarily responsible for making those trust fund deposits, you could still be personally liable. If you knew about it, you knew about the fact that they weren't paid, and you had the ability to cause them to be paid, you could be personally liable. That's why one of the things I tell people, I recommend to people, if you're asked to be on the board of an organization, for example, a nonprofit, one of the things that you should regularly do at your board meetings is get some verification, assuming that the nonprofit has employees, get some verification that the trust fund taxes have been paid. Because as a board member, you could be potentially personally liable, even as a volunteer board member of a nonprofit. There have been cases, there's a recent case just a year or so ago, where the board member of a nonprofit was personally liable for the trust fund tax. Now you might say, well, what if I hire, I have a payroll company. So I just send the payroll company money and then they make the deposits. What if the payroll company doesn't make the deposit? What if they abscond with the money? What if they lose the money? Well, that's their problem, right? Wrong. It's the employer's problem. The IRS even came out recently with a bulletin saying, hey, look, be really careful who you choose as your payroll service provider, because if they abscond with that money, if they don't make that deposit, you are responsible for the deposit. So now you've had to pay, you're going to have to pay the money twice. You have to pay it once to your payroll provider, who then has taken off with it, and now you got to pay it again to the IRS because it's owed. So making sure that your payroll service provider is bonded, for example, is really, really crucial. Number 6, vicarious liability. Basic concept in the law is that tortfeasors, somebody who commits a tort like negligence, right? Tortfeasors are always responsible for their own torts, right? So if you commit negligence, it doesn't matter whether you commit it while you're working in a corporation or for a corporation or you own a corporation or an LLC or anything else. If it's your negligence, you're always liable for that. The concern of business owners, of course, is vicarious liability. All right, that means liability for somebody else's actions. And in the employment context, employers can be liable for things that employees do. In fact, you can even be liable for things independent contractors do. It's all based on what we refer to as the law of agency. So basically, when somebody's doing something on your behalf, whether they are your employee or an independent contractor, they could potentially make you liable for their actions. Now, there's a couple of different categories of liability, right? There's contract liability and tort liability. Any type of agent might be able to bind you to a contract, right, depending on the facts and circumstances, but only employees can bind you to their torts, right? So if an independent contractor commits a tort, you're not responsible for that tort. However, if your employee commits a tort within the scope of their employment, the employer is responsible for their tort. So what can you do about this? Well, there's a couple of things you need to think about in this regard. The critical issue here is, who is the employer? If you personally are the employer in your personal individual capacity, then you're personally the one that is going to be liable for their torts, which is why typically if you have employees, my recommendation, the recommendation of any lawyer who knows what they're doing, is going to be that you operate your business within the framework of an entity, right? And there's a whole variety of entities you can use. You can use a corporation, you can use an LLC, you might even use a limited liability partnership, or here in Maryland and in about half of the states, we have something called a limited liability limited partnership, right? All of those things will protect you from vicarious liability. Now, they're not complete panaceas, by the way. There are still some theories that a plaintiff can use in order to argue that the employer should be liable. For example, there's something called the theory of negligent hiring, right? So you have an employee that commits a tort, but it turns out the employee has a history of committing those torts, right? I was involved in a case not too long ago that involved a company that hired somebody who had been a felon and who had been imprisoned several times for sexual assault, and they hired them in a job capacity where they had access to, vulnerable young women, basically, and they committed a sexual assault. And so, although that tort, could be the liability of the company, even if the company's a corporation, they could possibly argue that it's negligent hiring, and so the person who actually hired them could be personally liable. That's not a typical case. Typically, housing your business in one of these liability protection entities will suffice to protect you from personal vicarious liability. Of course, if you want to operate your business as a sole proprietor, and frankly, especially in Maryland, I don't see why you would. I mean, it's relatively simple and not very expensive to set up an LLC. You only need one owner. You can have a sole member LLC, and that will protect you from vicarious liability. But if you want to go it alone, if you don't want to have the protection of any of these entities, then you can protect yourself with insurance, I guess, right? That's the only other option. Workers' comp and unemployment insurance. Unemployment insurance is fairly straightforward. I'll tell you about it, but workers' comp, again, is one of those areas which is very commonly misunderstood. The requirements for employers in Maryland are very commonly misunderstood. So let's talk about both of these issues. Let's start with workers' comp. The general rule is that every Maryland business with one or more employees must carry workers' comp insurance. And that includes both full-time and part-time employees. Right? So if you have one or more employees, you must carry workers' comp insurance. That is the law in Maryland. There's no exemption for small employers, right? If you have just one employee, you have to have workers' comp insurance. There are some exemptions. If you're an agricultural business, right, and you have agricultural employees, and there's less than 3 of them, and your payroll is less than $15,000, there's an exemption for workers' comp. There's also an exemption with respect to the sole proprietor and the partners themselves, not for the employees of the sole proprietor and partners. If you have an employee, then you have to have workers' comp insurance, but you don't have to cover yourself as a sole proprietor. You don't have to cover partners. And then finally, maybe most importantly, is independent contractors. Again, that classification becomes important here, right? Because if they are properly classified as independent contractors, you don't have to get workers' comp insurance with regard to them. There are some other exceptions. These exemptions are elected. You have to specifically file an election. If you're an officer of a close corporation, right? A close corporation is a special type of corporation in Maryland. If you're the officer of a close corporation in Maryland, you can elect not to be covered by workers' comp. Again, this is just for the officers, not for other employees. If it's a non-close corporation, the officers can elect to be exempt from workers' comp, but only up to 5 officers. If you have more than 5 officers, only 5 can be exempt. If you're a corporate officer of a farm corporation and you own 20% or more of the stock, you yourself can be exempt. And again, I want to emphasize, this doesn't mean that other employees are exempt. You still have to have workers' comp insurance for the other employee. And finally, if you're a 20% owner and member of an LLC or a professional corporation, those are the last 2 categories. Again, you can elect to be exempt yourself, but it doesn't mean that your employees are exempt. Now, you have to actually do something to get this exemption. It doesn't happen automatically. You have to submit a written notice that includes the names of the individuals who are electing to be exempt from workers' comp. You have to send that to the Workers' Comp Commission and to the insurer who covers your other employees, assuming you have other employees. And you must file that, or even the people you see on this list, officers of a close corporation, et cetera, without this election, they have to be covered under workers' comp. This is the exclusion form, by the way. This is the form you fill out. I'm not aware, I don't think that you can do it electronically. I'm sure you can send it in electronically, but it's an actual physical form. And that's what you fill out for any of those exemption elections. How much does workers' comp cost? Well, it depends on a whole bunch of things: how big your payroll is, where you're located, how many employees you have, what industry you're in. Right? Workers' comp covers injuries on the job, right? So if you're in an industry that has a high risk of injury, obviously your workers' comp insurance is going to be more than if you're in a lower risk type of industry. Generally speaking, your rates are going to be anywhere from a little over $1 to $100 per covered employee. All right, that's a pretty broad range, but that's typically where the range is going to fall for workers' comp insurance. You have 3 options to obtain workers' comp insurance. You can just go to a private insurance company, right? Lots of private insurance companies write workers' comp insurance. You can apply for self-insurance. You can be self-insured for workers' comp, but there's an application process you have to go through. And that includes providing the state with audited financial statements and a whole bunch of other financial information. Or you can obtain your workers' comp insurance from the state fund. In Maryland, the state fund is run by the Chesapeake Employers Insurance Company. All right, so those are different ways you can get your workers' comp insurance. What if you don't do it? You don't have workers' comp insurance. You can be fined up to $10,000. The corporate or LLC officers can have personal liability for that fine, by the way. And if an employer deducts any part of the workers' compensation cost from the employee's wages, which you're not allowed to do, this is just an expense of the employer. You can't make the employees pay for it. You can actually be found guilty of a misdemeanor for doing that if you try to make your employees pay for your workers' comp insurance. Again, it's something that a lot of people don't know the law, and they figure, well, it makes sense. If this is a cost of my having you as an employee, it makes sense that I ought to be able to make you pay for it. You know, I can see where some people might reasonably come to that conclusion, but if they do so, they're committing a misdemeanor. Now, FUTA is the Federal Unemployment Tax Act. You have to pay a FUTA tax. Now, the federal unemployment is not an insurance. It's an insurance type product from the employee standpoint, but you don't actually buy an insurance policy. You pay a tax. The federal tax is required if you pay wages of $1,500 or more in any calendar quarter, or if you had one or more employees in at least some part of any day in 20 different weeks during the year. All right, then you're required to pay FUTA. For this purpose, by the way, all employees count, whether they're temporary, full-time, part-time, doesn't matter. So if you had one or more employees in 20 different weeks during the year, you have to pay the FUTA tax. The federal rate is 6%. It's only applied to the first $7,000 per employee, right? So it's you take the first $7,000 times number of employees you have, you know, only counting their first 7,000 of wages, and you multiply that by 6%. Now, having said that, there's also what's called a state credit, because the states impose unemployment tax as well. Basically, what the federal law says is if you pay your state unemployment tax, then you can get a credit up to 5.4% against your federal tax. So the end result of all that is that the federal tax has an effective rate of 0.6%, right? Because it's the 6% minus the 5.4% credit that you get for paying your state unemployment tax. Well, what's the state unemployment tax? Well, in Maryland, it applies to wages not up to $7,000, but to wages up to $8,500, right? So the threshold for paying the employment tax is larger, right? A larger portion of the wages are subject to the unemployment tax. The new employers start out with a rate of 2.3%, but after the first year, it depends on your industry. You actually get rated, depends on your industry and if you've had any claims, et cetera. If a new employer is in the construction industry and headquartered in another state, you got to pay 7% in the state of Maryland. And the range of rates for other employers go from 2.2%, or should be 2.3%, to 13.5%. Again, you have to have it. You have to pay it in Maryland, both the federal and the state. But remember, you get that credit against the federal. Employee handbooks and contracts. There's not a lot I want to say about this, but there's a couple of things that I think is important for every employer to know. As I mentioned earlier, in Maryland, employees are generally considered to be employees at will, which means you can fire them anytime you want for any reason you want, other than a discriminatory reason. We'll talk about that in a minute. And they can quit anytime they want for any reason. Question I sometimes get asked by employers is, they say, well, can I require my employees to give me a 2-week notice? The answer is no. You can request that they give you a 2-week notice, but you can't force them to do that. If an employee wants to quit, you know, right now and just get up and leave and say, I quit, they have every right to do that, unless they have a contract. Now, I will tell you that in most situations, even in situations where employers think they have a contract, they might not. Lots of lawyers draft documents that say employment contract across the top. But when you read the contract, frequently you'll find that it'll recite that despite what this document says, the employee will be deemed to be an employee at will. Well, a legal question arises then whether you have a contract or not, because in order to have a contract, you have to have consideration. And without getting into all the gory details, consideration basically means that both sides have to be agreeing to do something. Well, if you have a contract that says, I can quit anytime I want as an employee, and as an employer, you can fire me anytime you want for any reason or for no reason, what are you agreeing to do? Arguably, you're not agreeing to do anything, and therefore you don't have a contract. On the flip side of that, employers have to be careful about employee handbooks. Employee handbooks are really good things to have, right? They can contain all sorts of policies that you want the employees to know, but you don't want the employee handbook to be construed as a contract, right? You don't want the employee handbook to bind you as the employer. Now, most people who draft an employee handbook, right, certainly most lawyers, are smart enough to know that, we're going to have all sorts of disclaimers saying this is not a contract, nothing in this document binds us to anything. We can change this anytime we want, with or without notice to you, right? And so you want to have all sorts of disclaimers to make sure that it's absolutely clear that your employee handbook is not a contract. The problem is if it is, and then you even inadvertently transgress it somehow, you might be liable for breach of contract. Number 9 on our list is nexus and multi-state taxation. I mentioned earlier that states are getting really, really aggressive about taxing out-of-state businesses. And again, this is a topic that we could very profitably spend literally a whole day on, or actually multiple days on. It's become very complex. But here's the essentials. Basically, all of the states now say that if you have an economic connection, that's what we mean by nexus, an economic connection to our state, we could impose state tax on you. Now, what is that economic connection? Well, that might mean that you sell to people in the state. You have customers in the state. It might mean that you have employees in the state. It might mean that you have facilities in the state. All right. Now, the good news is that most states do have a threshold. Right. So, for example, if you just sell one item to somebody in Arkansas, Arkansas is not going to make you file a tax return. Most states have a threshold. Typically, it's 250,000, or sometimes as much as 500,000, or even more. That says you don't have to file a tax return until you hit that amount. But again, it varies from state to state. So if you're doing any kind of business in any state other than Maryland, you need to make sure what their rules are. You need to educate yourself about what their rules are, because, as I said, states have gotten very aggressive, and they're going after businesses who don't file and pay taxes in their state. And I'll tell you one story that indicates how aggressive states have gotten. As Jeff mentioned at the outset, I used to teach at the University of Baltimore Law School. And years ago, I ran into one of my former students in Logan Airport up in Boston. And both of our flights had been delayed, so we were just chatting for a while. And I asked him what he was doing. And he said, well, I work for the department, the Florida Department of Corporate Revenue, right? Basically the tax collector for corporate tax in Florida. And I said, no. I said, how do you like living in Florida? And he said, I don't. I live in Chicago. And this was before COVID, right? So it wasn't a telecommuting thing. He was working at the Florida Corporate Department of Revenue's office in Chicago. Many states now have revenue offices in other states because they know that they oftentimes have taxpayers in those states who have tax liabilities to their state, even though they're located in Illinois or wherever they happen to be. So my point is this: you cannot be too careful. If you are doing any business out of state, then the prudent thing to do is to have your CPA or your lawyer or somebody do an analysis to see if you have any reporting and tax payment obligations in those states. States are under a lot of budgetary pressure, and they tend to be very unforgiving with respect to taxes owed to them. And in many states, unlike the IRS, the IRS basically has 3 years to make an assessment of additional tax liability. In many states, they don't have statute of limitations. they can come to you 10 years later and assess a tax liability against you. All right, our final concern is the anti-discrimination laws. And again, this is a broad topic. I'm just going to talk about a few of these laws, and even the laws I'm going to talk about, of course, I'm only going to be able to talk about in sort of a cursory manner. But I just want to point out some of the issues that employers, particularly employers here in Maryland, should be concerned about. First, the Equal Pay Act of 1963. We have a long history in this country of paying women less than we pay men. Sometimes that's quite intentional. I remember growing up back in the 70s and hearing people say things like, well, you don't pay a woman as much as you pay a man because the man is usually the head of the family, right? They got to support the family, where the woman is just sort of working for fun. That was the attitude, just for extra pay or something. That was the attitude that prevailed in this country for a long time. So since 1963, we've had this Equal Pay Act. And basically what it says is you have to pay the same to men and women for substantially equal work. Note that this law, which is a federal law, applies to all employers. Again, doesn't matter if you're a small employer, large employer, what kind of employer you are. If you're an employer, the Equal Pay Act applies to you. Now, the trick, of course, in the Equal Pay Act is, what does substantially equal work mean? It doesn't have to be the same job title necessarily, nor, in fact, does the man and the woman have to be doing exactly the same thing, right? If they're using the same amount of skill and effort and responsibility, that's where it kicks in. And importantly, note that last bullet point on the screen: no showing of employer intent is required. So in other words, for somebody to sue you, for the EEOC to sue you under the Equal Pay Act, they don't have to show that you intended to pay women less than men, right? Or men less than women, for that matter. All they have to show is that there's a difference, that people of different genders, men and women, are doing substantially equal work, and they're not getting paid the same. Now, there can be differences for things like seniority and stuff like that, right? But if they're positioned the same, they should be getting the same pay. The distinction in pay should not be based on their gender. That's the Equal Pay Act. Another law you should be aware of is the Age Discrimination Act. The Age Discrimination Act, this only applies if you have 20 or more employees. So one of the problems, or one of the issues with all these discrimination laws, they tend to apply in different circumstances, right? So the Equal Pay Act applies to all employers. Age Discrimination Act only applies if you have 20 or more employees. It prohibits discrimination with respect to people who are over 40, all right? So you can't favor young over old, but it's okay to favor old over young, right? So if you want to have a rule that says, I'm not going to hire anybody unless they're 40 years old or older, that's fine. That doesn't violate the Age Discrimination Act. If you have a rule that says, I'm not going to hire anybody who's, unless they're under 40, that would be a violation of the act. There are exceptions. An employee can waive this for early retirement. Normally you can't force somebody to retire at a specific age unless they're an executive. Executives can be forced to retire at 65. But your average worker, of course, they might want to retire early, right? So you can offer an incentive, right, which employers often do. And if the employee agrees to that, then it's not a violation of the law. Title VII of the Civil Rights Act. Now, this is a federal act, but I want to specifically talk about its application in Maryland. By definition, in Maryland, as well as everywhere else, the Civil Rights Act applies if you have 15 or more employees, right? So again, 20 employees for the Age Discrimination Act, any number of employees for Equal Pay Act, 15 or more employees for the Civil Rights Act. In Maryland, now the Maryland list is of protected classes is a little more expansive than the federal list, right? And if you're an employer in Maryland, it's the Maryland list that counts. You can't discriminate on the basis of race or color or religion or sex or age or national origin or marital status or gender identity or genetic information, right? Or a refusal to submit to a genetic test, right? So if you want to require somebody to get a DNA test, you can't do that. They can refuse, and you can't discriminate against them for doing that. Or sexual orientation. What all of this means is that you cannot take a job action, meaning you cannot decide not to hire somebody or to fire somebody or to not give them a promotion or not give them a raise based on one of these reasons. Now, obviously, the question becomes, well, if I refuse to hire somebody or if I fire someone, how do you show it was for one of these reasons as opposed to something else? Well, again, those become factual disputes, which means that as an employer, you want to keep records. So if you're going to fire somebody because of poor performance, you want to make sure especially if they're in one of these protected classes, you want to make sure you keep records of that. So if they do come and come back and say, no, I think I was fired because of my sex or my age or my national origin or something else, you can say, no, we have the documents. Here's the reasons that we fired you. Right? As I said earlier, employees at will can be fired at any time for any reason, but not for a discriminatory reason, right? Not for a reason that's against public policy. And then finally, the Americans with Disabilities Act. This applies to employers with 15 or more employees. There's a special rule for schools that applies if you have 50 or more employees. And basically what it says is you can't discriminate against people with qualified individuals with disabilities, QIDs. That's a specifically defined term under the Act. And what it means is somebody has a disability, but they can perform the essential job functions, either with or without reasonable accommodation. They have the necessary skills and they have a disability. Again, the ADA doesn't say you have to hire them. It simply says you cannot not hire them based on their disability. And again, if somebody claims that that's the reason you're not hiring them, then the issue becomes one of proof, right? So documentation is always, a really, really good idea. Okay. Let me see if we have any other questions. See, we had a question about W-2 employees versus 1099 independent contractors. They say that the questioner says that they lean towards the W-2 format. Yeah, the IRS and the state is never going to question your classification as an employee. They'll leave that alone. They'll never say, the state's never going to say, nor will the IRS ever say, you have somebody you're counting as an employee, but they should be an independent contractor. That's not going to happen. Their concern is if you're counting them as an independent contractor and they should be an employee. All right. So those are the situations you want to be careful of. If you're counting somebody as an independent contractor, you want to make sure that the facts support you. In terms of supporting, it says independent contractor means a company can step back, liability falls on the 1099 person. Well, it depends on what you mean. You mean liability for taxes, for the employment taxes, yes. A human more robustly supported, providing benefits, etc. The consumer should prefer the people working as W-2. I don't know. I mean, I'm not sure that most people who deal with agents of a company have any idea if they're W-2 workers or independent contractors. When you deal with your lawyer or your CPA or your doctor, do you ask them if they're getting a W-2 or if they're getting a 1099? Does it matter to you? I don't know. I think the employee cares. And again, if you don't have the facts supporting you, the state will care. But those are the issues. Again, they can be complex, factually centered issues. So whenever a client calls me and says, look, I have a concern, or I have a worker, I'm classifying them as an independent contractor, or I want to classify them as an independent contractor, but I'm not sure, the answer to the question is, that's an essay question, right? So we have to look at all those different factors. What I do in situations like that is I literally do an analysis of those 20 factors. And based on that analysis, I give an opinion as to whether I think they're properly classified as independent contractors or employees. You can also file an SS8 if you're really concerned, but be careful with the SS8, right? Be careful what you wish for, right? Because you may file the SS8 and get an answer that's the opposite of what you were hoping to get, in which case you're stuck with that because it's binding on you and the IRS. Okay. I don't think we have any other questions, unless, Jeff, there are questions that I haven't seen, but I think I might have gotten them all. Thanks for attending our webinar today. Again, my name is Chuck Borek. I work here at Elville and Associates as an attorney, as a special counsel. The best way to reach me, you can reach me through Elville and Associates, by the way, but the best way to reach me is through at chuck@borekgroup.com or at 410-988-3820, or by contacting Elville and Associates. You can get to me either way. So thanks again for attending, and I hope it was enjoyable.
Well, thank you, Chuck, as always. And it looks like we do have a follow-up question from that person that sent in that previous question. And it states, is a family hiring home health providers better off hiring W-2 or 1099 if something goes wrong?
If it's the family that's hiring them, then invariably they're going to be a 1099 employee. You're not going to be in the business of providing. If you're not in the business of providing home health care to other people, then you don't have employees. So generally, you're either going to hire a business that provides you with individuals, and those individuals may be paid by the business, either on W-2s or 1099s. Again, I'm not sure that it matters to the person receiving the services. But if you're just hiring somebody to care for you or for a loved one in your home, invariably that's not going to be an employee. It could be, I suppose, but generally, you're not going to be giving them instructions or training or any of those things. So they're typically going to fall into the category of independent contract.
Okay. And so let's see here. And as a follow-up to that, thinking towards, is a family better protected by hiring from a company that pays W-2 versus 1099?
Again, I don't think the W-2 versus 1099 has anything to do with it. If you're using a company to provide services to you, then the company is going to be potentially liable. Presumably, the company has insurance or is bonded. Those are the things that are important. If the company doesn't have any assets, doesn't have any insurance, isn't bonded, then whether they're liable to you or not, it's not going to matter. You're not going to be able to collect anything. So again, whether the workers are paid, how the workers are paid by the company is not going to have an effect on that.
Okay. Well, thank you, Chuck. And so now would be your time to get those final questions into me, please. I'd like to thank Chuck, as always, for a great, well thought out presentation as he offers every quarter. And I'll go on the record now and would like to welcome Chuck back for next quarter for another webinar. Always appreciate your time and expertise, Chuck. So thank you very much. And so while we're waiting for any final questions, I'll say that I'll be sending the video out for today's webinar. I'll send the slides out again if for some reason you might have missed them and you want them still. And as we move forward with our webinar series in the next week or so, we're going to be really busy. Tomorrow we have what families need to know about planning for a loved one with special needs, presented by our managing principal here, Stephen Elville, on Wednesday the 20th at 7 p.m. So we have an evening webinar. We'll be doing estate planning and elder law essentials. And on that same day, actually, at 10 a.m., we'll be doing trustee selection, how to choose the right one for you, which is always a very popular discussion that we try to offer about once a quarter or so. And also jumping back a day, last thing I'll say, on the 19th, that'll be next Tuesday, part 2 of our wellness series, Navigating Unexpected Changes, with Dr. Michelle Fritsch and Aging Life Care Manager Ellen Platts. And so our first part went really well, really insightful and great information from our speakers that have been with us for a number of webinars. And so we're looking forward to part 2 of that series that's going to be ongoing. So that is it from the Elville webinar series today. Let's see if we have any final questions. And it doesn't look like we do, so I think we'll go ahead and call that a wrap at 11:59 today. I'd like to thank you for being part of our webinar today and hope you have a wonderful day. And Chuck's contact information is right there on the screen there if you want to reach out to him with any further questions or thoughts. Have a great day, everybody. Thank you.
Thanks, Jeff. Bye-bye.
Thank you, Chuck.